In today's video, we're going to talk about things that lawyers do to get in trouble. And when I say in trouble, it could be a client complaining to the state bar, a client leaving a bad review, a client filing a malpractice lawsuit, a client is filing other civil charges for damages, things that are not acceptable. And there are many of them. So, for example, if a client fires a lawyer, the lawyer is required to provide client's file. They cannot withhold it and say, give me $30 or otherwise I'm not going to give you the file. They have to actually provide the file. It doesn't have to be in physical form now. After COVID, everything is online, but it has to be in some sort of form. If a client is asking to send a link, they have to send a link. If a client is asking to send it in USB, I would just send it in USB, whatever the client wants. Failing to update the client on a case. So if I, as a lawyer, receive an offer letter, I immediately send this offer letter to my client because a lawyer is required to update the client about anything related to the case. Ignoring calls and emails, missing certain deadlines. So if, let's say, a deadline to provide discovery responses on Friday, you bet a lawyer should be sending everything received from the other side a month before, which is typically the deadline where the client would need to start gathering documents. Then if a lawyer notices that this is not a deadline that the client can meet for whatever reason, then the lawyer is required to ask opposing counsel to give extension. And usually opposing counsel will give a courtesy extension, especially if there is a good reason. Mishandling client case, exposing confidential information. For example, everything that an attorney and client discuss is confidential. So a lawyer is not allowed to go and tell someone else with the client's name and tell them whatever happens, even if it's a parent. So for example, I have cases where a client hires me, but the parent is paying, and I always have the client and the parent sign and myself sign as third-party fee waiver. What it means is that whoever pays for the fees does not get to dictate the case, meaning they cannot say how the case should be handled. They can try to say it, but I will remind them, look, just because you pay doesn't mean you dictate the proceedings, especially if it contradicts with the client's wishes. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. Another issue that comes up is billing. Billing is absolutely required. Billing has to be specific. It has to be timely, which is, there's no guideline when the billing should be, but typically it happens every 30 days. I bill weekly, so that's not a problem. A client has to have transparency about the money. And the money, usually, if it's not a flat fee retainer, goes to IOTA account, and then whatever the attorney earns will be taken from that IOTA into business account. So commingling is not okay. If a client terminates the case, the file and the money remaining needs to be returned immediately. Procedural neglect. We talked about coming unprepared to court, not providing evidence, happens a lot. Especially, I warn clients if they have domestic violence restraining order and give a flat fee amount to the lawyer. It's potentially dangerous because if the case takes a little longer, the lawyer might not be incentivized. And anyway, the point is, there are lawyers who are unprepared. If you notice that at the beginning of the stages of your case, run, because it gets worse. Ethical violation, bad-mouthing, coercing clients into settlements. You have to sign it. That's not okay. A lawyer's job is to counsel, and counsel means I am providing you as a client options. Option A, if you sign this agreement, that means this. Option B, if you don't sign an agreement, then it means this. And then the client can decide. Never say you have to sign it. I never say you have no choice. There is always a choice. You just don't like the consequences of a certain choice, but there's always a choice. Lying and misleading to court. And this is a tricky one. So if a client tells me one thing and I tell the court the other thing, then that's a it's an ethical violation under conduct to court. So I tell my clients, if you don't want me to know something, on one hand, in my retainer agreement, it says a client has to be honest with me. But on the other hand, if a client tells me something that they want me to represent to the court differently, for example, if they say the date of separation is today, but I'm going to claim it in 6 months because I want more money, but in reality we're not planning to be together, things like that can get a client and attorney in trouble. So in that case, I have another video on this, what not to tell your lawyer. And finally, social romantic relationship with a client. That is absolutely no-go. It has been decided by Supreme Court. That's not okay. It cannot be waived. So I hope this video was helpful, and I will see you soon. Bye.